Okay, everyone, we're just going to get started now. I want to thank everybody for coming out and joining this webinar. We have a special guest tonight, which I'll get to in a moment. If anybody's unfamiliar, my name is Rob Dix. I work at Rent Panda. What we want to do is we want to create a continuing educational series, speaker series for landlords and investors, where we have an opportunity to provide education on various topics in the rental space. Tonight, we have a special guest and Panda partner presenting. Please welcome Dan Schofield. He's a partner at SFG Paralegal Services who has many years of experience with a focus on the Human Rights Tribunal of Ontario, Small Claims Court, and the Landlord and Tenant Board legal matters. Without further ado, Dan, definitely take it away.
Thanks, everyone. Thanks, Rob. I appreciate it. So for those of you who don't know me, I am the interim managing partner at SFG Paralegal Services. We are a paralegal firm that's primary focus is landlord and tenant. I also do human rights, small claims, as well as regulatory tribunals. So I also represent landlords and mortgage agents in front of their regulatory body. Today, we're going to cover the top 10 most common landlord and tenant board issues. Now, I really want to be clear. This is top 10 only because these are the top 10 issues that my firm sees on a regular basis. So there's no official list on the Landlord and Tenant Board website. That's not what this is. And also, before I get started, I just want to be clear that none of what I'm saying tonight should be taken as any sort of legal advice to you. And also be aware that when I am answering questions, I'm not allowed to answer specific questions. So you could ask theoretically, when should an N4 be served? But I can't answer a question like, my tenant hasn't paid me rent yet. Should I serve a notice and what should I do? So with that in mind, let's get the show on the road. This is my contact information. If any of you ever require the need to reach out to me, my phone number is here. My email address is here at dan@sfglegal.ca. And certainly I will answer as many questions for you as I can here tonight. And I'm happy to schedule brief phone calls or emails with anybody else who needs follow up. So what are the 10 most common landlord and tenant board issues that we see as a firm? Non-payment of rent, obviously, persistent late payment of rent, damage, reasonable enjoyment of other tenants, interfering with rights of the landlord, tenants wishing to sublet or terminate their leases early. I'm going to also cover mistakes on notices, an illegal entry, what happens if a tenant is denying entry, eviction for owner or purchaser's own use, minor human rights accommodation, smoking and cultivating marijuana, as well as small claims versus the landlord and tenant board, which as of September 2020 is a lot more clear, but it wasn't always. But I am going to spend some time talking about it because I still see, certainly we get inquiries, and I still see a lot online where landlords are saying, well, I want to take my client to my former tenant to small claims court. And the short answer is in most cases, you can't. So your tenant's bounced a rent check, hasn't paid utilities, hydro, water. What should you do? This is something that we get a lot of. So first of all, when should a non-payment of rent notice be served? At SFG, we deal with everything from the one-door Mon Paul landlord all the way up to 2,000-door corporate landlords. And I advise everybody the same, regardless of whether you are a small door or a large door landlord. And that is, if rent is due on the 1st and you have not received rent by 11:59 p.m. on the 1st, on the 2nd, you should be issuing a non-payment of rent notice. I realize that your tenants may be good tenants. I realize that sometimes tenants will run and fall on hard times, and sometimes they need a couple of days. But overwhelmingly, most of the landlords that come in and talk to us are already a month or two behind before they even start the N4 process. Prior to COVID, this wasn't such a big deal. You could usually get a hearing and an eviction within 45 to 60 days. And if you happen to act a little bit late on a notice, maybe you'd be out a couple additional months rent, but that's really all that would happen. In today's environment, where we're seeing hearings sometimes take as long as 8 months to get to, and then once the order has been issued, once the hearing's been had, an additional 60 to 90 days before an order is issued, you could potentially be without rent for a year on a non-paying tenant. And that's why it's important to react immediately. Your tenant will have a 14-day voiding period on the N4 to pay any rent that's owed. Your tenant can pay any arrears up to the day of the hearing. Once there is a hearing and an eviction order has been issued, they'll have 11 days to pay the order after it's been issued. There will be plenty of opportunity for your tenant to catch up. The last thing you want to do is be behind the 8 ball. What should the notice include? It should always include the exact rent, including dollars and cents. Just to illustrate how important this is for you, when you do an intake with SFG Paralegal Services, we ask you your rent 3 different times. We ask you your rent when you get a disclose your lease to us. We do a landlord intake form where we ask you to disclose the rent. And then ultimately, before the notice is served, we email it to you, ask you to approve it for form and content, and specifically to double check the rent amount. And this is important because the act requires that notice to be perfect. And just to illustrate this point, we had a client come to us, on the intake forms, rent was $1,700 a month. We checked the lease, it was lower, but he said there were some increases. We serve the notice, give the notice to him to approve, $1,700 a month. He approves it at $1,700 a month, and we get to a hearing 4 months later, and the tenant's legal representative raises the fact that the notice is defective. And I didn't know why. The termination dates were fine and everything else, and my client kind of looked at me and I looked at my client, and the legal representative said the rent for this property is $1,699 a month. We were off by $1, and that was enough to cause the entire notice to be defective. You shouldn't include NSF charges. You shouldn't include any sort of self-imposed interest. And you shouldn't talk about any rent increases that are not done in accordance with the Residential Tenancies Act. So if you say to your tenant in October, starting November 1st, you have to pay me an extra $25 a month, and that tenant stops paying rent, and you take them to the board on an N4 and you include that illegal increase, because it was an illegal increase, and you go to the board 8-10 months later, that notice will be defective because that increase was not done in accordance with the act. So it's important that you understand. I can explain how to do rent increases later if that's something that you want to know and understand, but it's really important that it be done perfectly. It should include the names of all the tenants and not the occupants. And you're going to see this statement throughout this presentation. And let me explain to you why it's important. If you sign a lease with Bob, and 6 months after the lease begins, Jen moves in with Bob, and they are now a couple. And they stop paying rent, or there's an issue with damage, or there's an issue with something else. And you start naming Jen as a tenant on the application. You are running the possibility of creating a situation where Jen has, unbeknownst to you, become a tenant with all the rights and responsibilities that come with being a tenant. So then if you serve an N12 notice later down the road, or if you serve some other notice later on down the road, and you only put Bob's name on it, they're going to argue that the notice was defective because Jen is a tenant. And when me as a legal representative or you as a landlord say, but only Bob signed the lease, they're going to pull up these previous notices that you served with Jen's name on it. And they're going to say, well, if she was only an occupant, then how come she was listed on these other notices? So it's really important that you only include the tenant, you don't include their kids, you don't include any other occupants, and you only include the named tenant. Now, there was some controversy about this. I think it's kind of worked its way out. But there was some controversy over who could prepare notices. Could a property manager prepare a notice? Could somebody else prepare a notice? That was largely taken care of last year by the divisional court. And the divisional court, Rivera and Elevant, basically said that any person acting on behalf of a landlord can prepare a notice. It could be the landlord itself, it could be a property manager, it could be a real estate agent who's helping a landlord out. Anybody can prepare and serve the actual notice. However, only the landlord or a licensee of the law society can file the application and proceed to a hearing on the landlord's behalf. So anybody can create a notice, only a licensee and a landlord can file the application and move forward towards the tribunal. Now, persistent late payment of rent, we get this a lot where the tenant pays rent, they void the N4 every month, but they're always paying 15 to 20 days late. And they've always paid before the termination date on the N4, so it's never been filed. And landlords are asking, what should they do? Well, persistent late payment of rent is when a tenant is typically late more than half of the length of a period. So a year or 2 years or 3 years. Usually within the last year is what the board will really consider as cogent and important. But usually it's when somebody's paid their rent late at least half the time. Now, when should an N8 be served? I've served them when it's been when rent has been paid late, like once or twice. Usually what happens when you get to the board on an N8, if there's no rental arrears and there's no N4 in play, is that the board's going to order something called a pay on time order. And the pay on time order will say that the tenant has to pay their rent on time and in full for at least 1 year. And if they're late, the landlord's not required to serve any additional notices. They can simply go right to the board and apply for an eviction based on the late payment. Although it's not required, N4s should usually be served because it builds you some evidence. You should keep copies of those N4s. A really important thing that you should have is even if it's only done in Excel, is you should have a rent ledger that talks about the month, when rent was due, and when rent was paid. And if it was paid in stages, the dates of those multiple payments. Again, what will most likely happen is a pay on time order. What the board's also going to look at is what was the behavior of the tenant after you serve the notice. So after you serve the notice, did the tenant continue to pay late? This is really important. We tend to use N4s and N8s combined together, but you can serve them on their own, even if it's just a warning to the tenant that you've had enough of their bad behavior as far as paying rent late. By the way, I know I'm going through this really, really fast. The presentation is usually about 30 minutes, and I usually get 30 minutes or more of questions. So even though I know I'm going through it fast, I'm happy to answer any questions that you have. And I'm also prepared to provide the presentation later so you can focus more on what I'm saying than what the words are on the slide. So damage, reasonable enjoyment of other tenants, interfering with landlord lawful right and privilege. So you inspect your property, and when you go into the property, you smell a strong ammonia smell. There's stains on the broadloom floor. There's scratches on the door, kitchen cabinets. They appear to be caused by the tenant's pets. The tenant doesn't want the property to be shown or visited unless they're present and insists the landlord be there to supervise all showings. Is the tenant being reasonable? Now, the reality is that for 3 and 4, no, the tenant's not being reasonable, and I'll get into that. And for 1 and 2, you know, if you visit your property and you see that the tenant has caused substantial damage, we're going to talk about what that is. So what is damage? Damage is anything other than wear and tear on a rental unit. And if you're not sure whether you have damage, you should call a lawyer or a paralegal that does LTB to discuss what the damage is. Just to give you a really good example, I'm going to share another screen here for a moment. Rob, can you just confirm that you see what looks like a table?
Yep, absolutely. Yep, it's there.
All right, perfect. So this is an Ontario regulation. It's 51606 under the Residential Tenancies Act. And what you see here at the bottom of the act, bottom of it, is you'll see what the board considers to be the useful life of different items within your home. So they will say, for instance, that a hardwood floor has a useful life of 20 years. They'll say that a linoleum floor has a useful life of 10 years. They'll say, carpets have a useful life of 10 years. That gypsum boards have a useful life of 5 years. Now, why am I bringing this up to you? Because this is one of the ways that I determine when you come to me as to whether or not something is actually damaged. This is one of the things that I look at. If you have a floor that is 10 years old, that let's say a carpet, for instance, that was 10 years old, and you go in and do an inspection and it smells of urine and there's other issues that are wrong with it, you have to replace that carpet. But because it's at the end of the 10-year life expectancy, you actually can't get the tenant to pay for the full value of that replacement, even though it's considered damage. You would use what's called the depreciated value of it. And then you would also have to prove, based on photos or other items, that when the tenant moved in, none of the stains or any of those things, obviously you can't prove smell, but none of the stains or any of the other issues that are on that carpet were present when the tenant moved in. So we'll kind of coach you through on how to do that, and we'll talk about approximate values of replacement and make sure that you're not claiming a betterment so that you can actually get the value of the property. Now, reasonable enjoyment of other tenants. So a tenant or a guest may not interfere with other tenants. This could be smoke, loud music, fights. It's your responsibility as a landlord to provide a notice of termination when receiving complaints from other tenants. Having said that, the tenant who's complaining must be willing to come and testify to you, for you. You cannot evict a tenant who, for loud noise or fights, if you don't live there, because you never actually witnessed the event itself. You witnessed the fact that someone sent you a text message about it. You witnessed the fact that somebody sent you an email about it, but you didn't witness it yourself. So the person who's complaining has to be willing to come, and they have to be willing to participate in the process. Now, let me explain to you why that's important. And there's this case down here called Volumetric Capital that talks about the fact that anytime you serve a notice of termination, like an N5 or an N7, you have to provide the date, the time, and the event that occurred. And this is so that a tenant is capable of mounting a defense, because it can happen, and it does happen, that one tenant simply doesn't like the other tenant, and therefore is in effect creating a situation hoping that you will evict that other tenant for something that never actually occurred. This has happened to me on a number of occasions. One of them happened to me just prior to COVID, where the white tenant on the main level didn't like the black tenant on the second level and accused them of dealing drugs and smoking drugs and playing loud music. And they were very detailed. They gave dates, times, everything that you could possibly imagine in order to back up the application. They gave it, including texts to the landlord at 1:30 in the morning, 2 o'clock in the morning, 2:30 in the morning, saying, they're at it again, you need to help me. Well, it turns out that by providing dates and times, it actually turns out that the tenant upstairs wasn't even in Canada at the time of a lot of the complaints. They had flight itineraries, Uber receipts, hotel receipts to show that they weren't even anywhere near the rental property for a large majority of the complaints. We actually ended up evicting the tenant that was complaining because she acted in a way that was contrary to landlord's lawful right and privilege. But that's why the requirement for date, time, and event exists. You can also evict tenants if they are guilty of a bylaw offense for which you could be fined. So as an example, we'll get tenants sometimes who will put up an above ground pool in the backyard, and then bylaw comes along and says, well, there's no fencing and there's none of these issues exist, that none of these safety things that you're supposed to have exist. So therefore, if you don't take it down, we're going to fine the landlord $5,000, $10,000, $20,000. That is a reason that you can evict the tenant, even though you haven't actually incurred the fine. You can also evict a tenant for refusing you reasonable entry. So under Section 27 of the Residential Tenancies Act, you as a landlord have what I would call an absolute right of entry to your rental property, as long as you provide the tenant with 24 hours notice, and that the entry is for a lawful purpose, such as an inspection or to fix something or repair something. The tenant can't, excuse me, folks, I'm just getting over a cold. The tenant can't refuse you the ability to go into your unit. Refusing you the ability to go into your unit is in itself grounds for eviction. Now, a tenant can choose to be home. If a tenant has dogs or cats and they want to put them into a room and keep them secure, that is their choice. It's also your choice to enter if there's dogs loose in the property. That's something that you need to consider. But it can't be something that the tenant insists on. And if they insist on it and they refuse entry, you can certainly file notices to evict them as a result. Subletting and early termination. Now, I'm going to caveat this. Real estate agents, if you're here, I'm going to apologize to you in advance because you hate it when I say this. There is absolutely no benefit whatsoever to a 1-year lease. It stops you from selling your property. It stops you from doing anything with the property during that 1-year term. Well, I shouldn't say it stops you from selling it, but it doesn't allow you to evict the tenants for that entire term unless they've done something wrong. But the tenant has several ways to walk out on a lease. Okay, so I can request a sublet. If you refuse, I can terminate in 30 days. I can request an assignment of the lease. If you refuse, I can terminate that within 30 days. If I ask you for a sublet or an assignment and you fail to respond to me within 7 days, I can terminate my lease within 30 days. But here's the other thing. I just don't need to pay my rent. The moment you serve an N4 with a termination date on the notice, my lease is over. You have lost all right to collect rent from me as long as I vacate by the termination date on the N4 notice. So I would argue that you really should be looking at month-to-month tenancies as opposed to yearly tenancies. The only kind of caveat to that would be if you have a really good tenant who pays rent on time and maintains the unit really well, and they ask you to renew on a yearly or 2-year basis because they don't want to have to worry about having to find another place to live after during that time period. Look, we all know that those tenants are worth their weight in gold, and you probably want to do something to accommodate them. But on a simple month-to-month basis, I would argue that yearly leases, there's no real advantage to them anymore. Here's Section 95(4) of the Act, which talks about assignments and refusing of assignments. They all talk about how the tenancy can terminate after 30 days. This also works for subletting. You cannot charge a penalty to your client if they terminate a lease early. You may be able to take them to the board and seek reasonable costs to lease to another tenant, maybe the commission for a real estate agent or the cost to list the property somewhere else. But that's all you're going to get. If they terminate 3 months into a 12-month lease, you're not getting that other 9 months. It's just not going to happen. So again, what's the point of having it if the only person it protects is not you? So mistakes on notices. Termination notices must be error-free. And this is where I have the conversation where I talk about the difference between a judge and an adjudicator, because a lot of people don't know the difference. So let me explain it. A judge looks at existing case law and precedent and makes decisions. They have something called judicial discretion. So for instance, they have something called judicial discretion if it's absent from legislation. So if, for instance, in the Commercial Tenancies Act, where it doesn't require a unit number on its face to be entirely correct, a judge can take judicial notice and say, oh, well, that's unit 3. I'm going to amend the style of cause to say that unit 3 is the unit we're talking about. Because the Residential Tenancies Act specifically says within the act that the rental unit must be clearly identified, that the address must be clear, that the tenants' names must be clearly identified, that the rental arrears must be clear, that the N5 termination or the N4 termination notice of date of termination on the notices must be correct. An adjudicator does not have the discretion to accept a mistake in those things. So it's really important that any notice that you submit must be error-free. Again, if there's a unit number not being placed there or a notice is not served properly, and I had this the other day actually. I don't represent tenants very often, and I certainly don't usually represent them on non-payment of rent. But in this particular case, I had a gentleman who I actually do work for his company who had not been the tenant somewhere for 24 months. He literally moved out before COVID. And at some point in the last year, the person who remained in the unit stopped paying rent. And the landlord served a notice and kept his name on the notice because he thought, well, if I get an order against this person, it will be easier for me to collect. But the reality is he wasn't a tenant anymore. He had served a proper N9 2 years ago. The landlord knew he didn't live there. He was just simply trying to understandably, because they were frustrated, he was simply trying to collect his rent arrears, but he did it wrong. So when he said that he served my client in the mailbox of the rental property, I argued that that wasn't served properly because he didn't live there. It didn't come to his attention. And how could you possibly be served in the mailbox of somewhere you don't live? And that notice was dismissed as a result. It's important to note that and this is why a good legal representative is also important, because 20 minutes before I had called the landlord's legal representative to the side and I said, look, my client doesn't live there. Your client knows he doesn't live there, but you have a valid notice of termination against this other tenant that I don't represent. So just pull my guy off and I'll keep my mouth shut. I'll just keep going on about my business and pretend that there's no issues with service because I don't help this other tenant. I'm not retained by them. I'm only retained by my guy. And their legal representative wasn't capable of seeing the argument. And as a result, they have to start all over again. If there's a mistake in service or on the notice, we have to start all over again. This could cost months. Now, remember what I said before about anybody, including real estate agents, being able to prepare notices? So let me put it to you this way. Even though you are capable of preparing it, chances are as a real estate agent, you don't have your errors and omissions insurance that would cover you for a landlord tenant board notice. And if a real estate agent were to serve the notice and it was to be incorrect, it's possible for you to sue that real estate agent. It's possible for you as a real estate agent to be sued and be liable for the damages that landlord incurred because you did something wrong. Illegal entries. So all notices of entry, unless it's an emergency, must be in writing. Email or text messages are fine as long as the tenant consented to it on the Ontario Standard Lease. They should be given at least 24 hours prior to the entry and must be as specific as possible. In other words, even though the Act says the entry must be between 8 a.m. and 8 p.m., you actually can't use that as a time window unless the situation calls for it. Most of the time, your window should be a few hours. If it's a landlord or an agent booking a showing of a property, they should try and give themselves a little bit of extra time. So for instance, say between 2 and 5 is a 3-hour window. It's probably a very reasonable window. And that gives you some leeway. If you say you're going to be there from 2:30 to 3 and you end up showing up at 2:20 or showing up at 3:10, that's no longer a valid entry. That's now an illegal entry because it's outside the time that you gave the tenant. So it's important to give us, fairly good windows, 2, 3, 4 hours. If it's something for like the delivery of an appliance where they say between 8 and 5, or if you have a contractor who's going to show up between 8 and 5, you can certainly list that on the notice because it's for a specific purpose. But your entries should always be as time specific as possible. You should always knock and announce yourself, even though you've given the notice of entry. I can't tell you how many times we've had clients get in trouble because they walked in on somebody who was having a shower or, doing other things because they didn't knock and announce themselves. Well, like I said, there's no requirement that the tenant be home. It's their choice. If a tenant refuses entry, that could be grounds for an eviction. Now, this also includes, and I get this with multi-door landlords where they're next door and they're like, oh, well, while I'm here, let me knock on unit 3's door and see if they'll let me in. And they think that because, Bob in unit 3 let them come in, that it's not an illegal entry. Well, it is. In Rona Toronto Community Housing, which was a divisional court case, Rona was a tenant at a TCHC property. The superintendent knocked on his door and said, hey, do you mind if we just come in and check your heaters to see if they're working? He allowed them in and then later took them to the landlord and tenant board, or at that time, the rental housing tribunal, and said, I didn't agree to these people come in. It was a power imbalance. They were knocking on my door. Even though they asked if they could come in, and I guess I could have said no, I felt pressured to say yes. He let them in and he received $1,000 for that illegal entry. And adjudicators do use that as a guide. I've seen, a person get hit with 8 times $1,000 fines for multiple illegal entries just because they refused to do things right the first time. And it is really a refusal because with 24 hours notice, usually that's enough time. And that would be allow you to give your tenants proper notice. So evictions for owners, purchasers, own use. So let me talk about this a little. This is a big one that comes up. If you are a seller, if you are a landlord and you are selling your property, I'm going to tell you right now that we would advise you, if you were to call us, that under no circumstances could you sell your property with a vacant possession clause. Even before COVID, that is advice that we gave sellers of rental properties. It's really, really important that you listen to me on this point, because even though the N12 notice is a 60-day notice that's given on the last day of a rental period, as tenants have shown, they understand that they have the ability to wait for a hearing. And a lot of them do not move out within the 60 days that's on the notice, and they do wait for a hearing. You have no legal recourse against that tenant. You cannot sue them for any losses that you incur because your deal falls through. You cannot sue them for any losses, for not complying with the notice. They have a statutory right to a hearing. So right now, that process could take up to a year. So just remember, when you're selling your property, even if you give the notice, do not promise vacant possession. If you are in a position where you have to promise vacant possession, build unlimited extensions into the deal so you can extend it 60 days at a time until your matter is disposed of. Compensation needs to be paid to the tenant prior to the termination date on the notice. I will get a lot of clients come to us whose hearing is a month away, and they say, well, no, we haven't paid compensation yet because the tenant hasn't left. Well, the compensation is not tied to when the tenant leaves. the compensation is tied to the termination date on the notice. And if you don't pay the compensation by the termination date on the notice, the application will be dismissed. There will be no discussion on it. It'll just be dismissed. The declaration needs to say that if it's for sellers, if it's for owner's own use, that the person moving in intends to stay there for at least 1 year. And that they can't, and they understand that they're not allowed to sell or re-rent in that time. Now, purchasers' affidavits are a little bit different. It just needs to say that they intend to occupy the unit. There is no statutory requirement that the purchaser stay there for at least a year. But if I was a betting man, I would suggest that if there is another amendment to the RTA, that the RTA would also say that a purchaser needs to live there for at least a year. However, it doesn't say that yet. So they have to swear that they are at least going to occupy the unit within a reasonable time. Now, if it is found that the person didn't move in, or the property was sold during that 1 year time, the fines can be quite significant. It could be the difference in the tenant's rent for a period of 12 months. So if you had a tenant paying $1,000 a month and now they pay $2,000 a month, the damages would be $12,000. On top of that, they can receive another award of up to 12 months of the total rent they paid prior to them leaving. So if the rent was $1,000 a month, that's another $12,000 that they'd be entitled to. Reasonable moving expenses, as determined by the board, to a monetary limit of $35,000. And then on top of that, the landlord could also be fined a significant amount of money. Personal landlords, I believe it's $50K. Corporate landlords, I believe it's $250K. It's really something that you want to make sure is being served in good faith as a result. We get a lot of landlords who will say, well, my tenant's behind on rent, so I'm just going to say that I'm moving in because it's easier to evict them. It's not easier to evict them that way. And you're opening yourself up to a huge amount of liability. And I would invite anybody who thinks that that's something they might want to do to call a good paralegal and get some legal advice. Human rights accommodation. So, landlords need to accommodate tenants to the point of undue hardship. I'm not going to get into the human rights code in any sort of detail in this presentation. I do have a human rights in the residential leasing presentation, just for your knowledge. It's about 3 hours long, and it's not really something that we would get into at 7:30 on a Tuesday night. But you do have to accommodate your tenant to the point of undue hardship. This could mean including installing ramps or rails to allow tenants who have a physical disability to access the rental unit. Showings and inspections can be refused, and they should be accommodated if they fall on a religious holiday. Showing and inspections can be refused and should be accommodated if the tenant is elderly or they have small children and they may go to bed earlier than, let's say, a teenage, a mid-40s couple with some teenagers. That should be respected. And showings and inspections can be refused and should be accommodating if the tenant or their children is under disability. Now, let me explain a situation that happened not long ago at the Human Rights Tribunal, where a realtor and a seller were taken to the tribunal, and the tenant was successful in getting a $100,000 judgment against both, where the landlord wanted to sell, and the tenant said, look, I have no problems, but I would appreciate it if you could only show the property when my son, who is autistic, is not home and is at camp, because my son, who's autistic, is very sensitive to changes in the environment and is not good with new people. And this will ultimately be very hard for him. And both the landlord and the real estate agent refused that request for accommodation. They continually entered when the child was home, and it ended up resulting in the child being hospitalized because they actually got so frustrated they started smashing their head against a wall. And as a result, there was some pretty hefty awards given to that tenant. So if the child is under disability, or if there's a person within the unit that's under disability, you really should look at what is required to accommodate that person, as opposed to just, sticking somebody into the unit regardless. This is kind of the last thing I'm going to get into. Leases should include a non-smoking clause if you wish to enforce one. If a non-smoking clause is absent from the lease, you cannot enforce it unless the smoking is so bad that it severely impacts other tenants. A non-smoking clause can include smoking, vaping, and cultivating of marijuana. When dealing with marijuana, you really should talk to somebody who's familiar with the Ontario Human Rights Code and their RTA. I had a case in Barrie where a tenant took out a medical grow certificate on the rental unit. They lied and said that they own the unit. Health Canada didn't check. And they were given a license to grow 260 marijuana plants in the basement of the rental unit. We ended up evicting them because of the damage that it caused. But it would have been much easier to evict them had we had a lease clause that said you cannot cultivate marijuana regardless of licensing status in the house under any circumstances without owner consent. The one thing you cannot exclude are religious practices. So you cannot exclude incense or Aboriginal smudging. They would be, they could potentially put you at risk on the Ontario Human Rights Code. So you really do want to speak to somebody if you're not familiar with whether or not something should be allowed or could be allowed. Again, with Bill 184 coming in September, it really makes this clear. Basically, any tenancy that terminated after September 1st, 2021 should be taken to the landlord and tenant board within a year of the tenant vacating. Any tenancy that terminated prior to September 1st, 2021 would have a 2-year limitation that you could take to small claims. After September 1st, 2021, you would file an L10 application within a year, and you would be able to claim both rental arrears and damage to the rental unit, provided that you pled everything properly and created a schedule that would allow an adjudicator to make a decision. So folks, that's really the end of this presentation. Again, it's kind of a down and dirty late night presentation. So I wanted to make sure that I didn't overwhelm you. I'm sure there was a lot of information there in a short period of time. But I'm free to, I know it's 7:45, but I'll stay on as long as I need to in order to answer the questions. So let's get to it.
There's a few in the chat. Dan, do you want me to just say them out to you and we'll go from there?
Sure.
So the first one is wondering if you can serve an N12 after there was a recent furnace issue. Wondering if the tenants can blame the landlord on human rights violations as the tenant likes the place and doesn't want to leave.
Okay, so there's a lot to break down there. So for an N12 to be successful, the landlord has to do a declaration that says they intend to live there for a period of at least a year and not sell or re-rent. That is the test for good faith. Unless that landlord was unsophisticated enough, I use that term to replace the word stupid, just so you know, to have something in writing that says, if you don't agree to pay $500 more a month, I'm going to serve a notice that says I'm moving in. Or, yeah, we broke the furnace and we're not going to fix it because we want to move in. If those text messages exist, it could potentially cause a problem for you. But just the mere fact that there was a problem with the furnace before you serve the N12, no, it's not a big deal. That's not the test. The fact that the tenant may have been late paying rent, or even that the tenant got served an N4 because they hadn't paid rent. And then 6 months later, you say, look, I can't afford 2 places now, so I have to move into this rental unit and sell the place that I'm currently in. It may require some explanation, but it's not on its face going to be fatal.
Thanks, Sam. That's a great detailed answer there. Can you talk about options for a landlord if you have a tenant with behavior issues and you are doing a cash for keys? Who can be present if the landlord prefers not to be at the exchange?
Property manager, friend, anybody who's responsible about things. I would suggest that in some cases the police, depending on the jurisdiction, may be willing to come and be present when the keys are exchanged. When I have that situation, I just tell my clients to say, look, leave the keys on the counter, text me when you're available, text me when you're gone, and be like at the Tim Hortons around the corner or at the Starbucks around the corner. And when the tenant says keys are on the counter, I'm out, you're only a couple minutes away, so you can go in really quick and secure the property. If it's one of those situations where you have to exchange money, then obviously that situation's not going to work, but just be present. So look, we live in a first party consent country. And what that means is that as long as you're an active part of a conversation, you can record it. Okay. So if Rob and I are having a conversation, Rob can record the conversation, or I can record the conversation without telling Rob that I'm recording it, because we're both active participants. But if Hart, who's hiding on the side here, hi Hart, never said hi to me, okay, decides to record the conversation for both of us, that's illegal because he's not an active participant. Now, why do I go into that? I go into that because this is what I tell people. If you're really super concerned, the worst thing you can do when you walk into a place is have your phone out. Be like, I'm recording you. Go to Amazon, buy a body cam for like $50 that looks like a pen, stick it in your front pocket, and record the entire interaction without ever saying a thing. And nobody knows that you're recording except for you, which is fine because you're an active member of the conversation. And if there's a problem, you have proof that whatever occurred wasn't your fault.
Great advice. Thanks, Sam. I've got a bunch more coming in, so I'll just keep going.
Yeah.
Can you share your thoughts about the LTB maintaining a list of tenants and landlords who repeatedly act in bad faith?
I'm not sure the LTB does keep a list of landlords who act in bad faith. I mean, the Landlord and Tenant Board certainly has the ability to go in and search a party's name internally and see if applications have been filed and what the disposition of those applications are. If something has been, like, I'll give you an example where there was one situation where the landlord said, I'm moving in. And then at the hearing, it was found that that was in bad faith. And then 2 months later, he serves another N12 and says, I'm moving in. Well, the circumstances haven't changed. And when the tenant brought up the fact that they were there 2 months prior, the board just went in and did the research and said goodbye. But I don't think there's a list anywhere that an adjudicator kind of flips through to see if something was served in bad faith. I'm not aware of something like that existing.
Yeah, I'll keep moving on. This is about dropping off a notice. So is dropping off a notice in their mailbox enough? How do we prove they received it, they got it, and that the landlord didn't just say they put it there and, you know, potentially could be lost or whatever it may be? Like, how do you prove that you've dropped it off?
This is a question I get asked a lot, and I'm going to give you the same answer that I would give you if you were paying me to do work for you. Canada Post regular mail. Okay, let me explain to you why. Yes, you have to add 5 days to the termination date on a notice. All right. So in the case of an N12, if you serve it too late, maybe you have to give 90 days notice as opposed to 60, which right now is kind of irrelevant because your hearing's still 8 months away, regardless of when your notice termination date is. Canada Post regular mail is the only method of service that the board deems served after 5 days, meaning the tenant could come with 20 witnesses to say, I never received the notice. And the board will go, oh, well, it went Canada Post, it was deemed served after 5 days. Too bad. Whereas if you in the mailbox or under the door or any of these other things, there's, of course, there's could be an interpretation. I mean, we had one situation not happen to my office, thank God, it happened to someone else, where the person claimed, well, yeah, I received the N4 notice in the envelope, but not the N12, which was apparently in the same envelope. And because they put it in the mailbox and it was done by a process server, they had no way of proving that it was wrong. Right? So Canada Post regular mail, I don't care if you live next door. Canada Post regular mail, the tenant cannot argue receipt of the notice. Ever.
Canada Post regular mail. Got it.
Not signature required, not Canada Post 2-day, regular mail. Throw a stamp on it, put it in the mailbox.
How much notice must be given to vacate a month-to-month commercial tenant with no reason?
I do not do commercial tenancies. They are outside of my scope of practice. I cannot answer that question.
Figured that. Someone's asking specifically about your rate. I would just, Andrew, I'll drop the information in the chat. And I think following up directly with Dan would be a lot easier. There's very specific conversations needed to be had. I'm sure, right, Dan? I don't know.
Well, look, I mean, here it is. If you ask me without any context what my rate is $225 an hour plus HST. If you're asking me what my rate would be to do notices, I would say overwhelmingly for most notices, not an N5, not an N7, you're looking at around 1,500 plus HST plus filing fees, with some exceptions. We're not the cheapest. I'm going to tell you right now, we're not the cheapest.
Best to get in contact. I just give the information below. And for everybody on this webinar, we'll provide a post email and a way to contact Dan as well. I'll keep going. There's just a couple more. Does the rights of the old or previous tenant outweigh the new tenants who are waiting to move in? I don't know if that's enough context for you.
Does the rights of the old tenant?
Yeah. IT, sorry, I wouldn't know your full name there. Do you mind giving a little bit more context? I'm happy to unmute you if that's a lot easier.
Who are waiting to move in. Would it be fair then? Are you like trying to say that if the old tenant doesn't leave, what happens to the new tenants?
Well, I'm not exactly sure the context. We'll move on, I guess. And if, oh, sorry. Yes, they confirmed. Yes.
Well, the short answer is that the old tenants are your tenants until they leave. Yeah, I mean, they have more rights than anybody that you may have rented the unit to. That's why I always recommend to clients that they always, even though it means sometimes losing a month of rent, like you probably don't want a back-to-back tenancies if you have a tenant who may not leave.
Fair enough. Actually, I believe that's all of the questions, unless there's anything else that any of the participants would like to ask. I'll leave it open for 30 seconds here. Otherwise, Dan, as always, thank you again for joining us.
Oh, you're welcome.
Oh, we've got one question rolling in.
Yeah.
I think a little bit more context here. Continuing. So Dan, continuing to the proof of the Canadian mail conversation, what's the proof that the notice was mailed?
A certificate of service that says you mailed it, that you're supposed to tell the truth at, and when you're at a hearing, you're supposed to tell the truth. So conceivably, that would be the proof. If you're really, really concerned, what I do, just for sake of argument, is I will go to the post office I will have them put the stamp on it and stamp it, and then I will take a picture of it and I will save that to the file.
Okay, great. I have a tenant that wants to move her boyfriend and dog in. We don't want dogs. What can or should we do?
It's a bit of a more complicated question. The easy one that you're going to see on Facebook is you can't stop them from having dogs once they're already tenants, which is true for the most part. But if it's a shared house, if there's shared ventilation, if there's people who you can prove are actually allergic to dogs, not just saying that they're allergic to dogs, the short answer is you might be able to stop it. But if she's already a tenant, you can't stop her from moving her boyfriend in, first of all. And if the boyfriend has a dog, you really can't stop that either.
Can you report a non-payment or non-paying tenant to the credit bureau prior to the eviction order?
The short answer to that is yes. There are services that do it. The long answer to that, I'm not going to get into, it would be too long. But the short answer to it is yes, you can. There's services that do it.
Okay. And then speaking on the same topic of dogs, can anything be done about dog waste not being picked up?
Sure. Notices that say you're acting contrary to my lawful right and privilege by not picking up your dog stuff.
There you go. Couple more. Oh yeah, sorry. Hart just let in the chat. Check out front lobby. Here's another question. Can I collect first and last month's rent when the lease is being signed, maybe 6 weeks before the day of tenancy or first day of tenancy?
So this one's a little bit interesting because technically the act doesn't apply until the tenancy commences. So I know a lot of people that keep last month's rent when they sign the lease and then accept the first month's rent prior to the keys being turned over. I suppose there's nothing that would be quote unquote illegal about first and last month's rent being collected 6 weeks before the tenancy, if that's what the tenants want to do. But it would really be fact specific to each case.
Great. I think that's all for the questions. Dan, thank you again for doing an amazing presentation. Super insightful. Obviously, we could go on probably for hours and hours just based on certain subject matter. So, you know, hopefully we'll do one in the future with you. And thank you for everyone who came out as participants. You know, it's really nice to have a conversation as a collective group, and we'll keep continuing on this speaker series. So I've left Dan's contact information in the chat. We'll also send a recap email to everybody to reach out to Dan directly. But again, from everybody on the call, Dan, as well as Rent Panda, thank you again for joining and doing an amazing presentation.
Yeah, sounds great.
Thanks, everybody. And thanks, Dan. Have a lovely night, and we'll catch up with the next webinar soon.
Sounds great, all. Have a good night.
Have a good one.
Bye-bye.